I'm Eric Lanigan with Lanigan and Lanigan in Winter Park. I want to talk for a minute about dealing with underwater homestead property in bankruptcy. Basically, underwater property is property where you owe more than what it's worth. Very often in these situations, what we will do, even if the homeowner is continuing to pay the mortgage, is we will not reaffirm the debt. We will have the debt discharged in bankruptcy. Now, what that does, a couple things. It allows the homeowner to, in the future, if they decide for whatever reason that they want to leave or need to leave the property, they're no longer dealing with the issue of owing more than it's worth because they've discharged the debt. They actually don't have any legal obligation on the debt. But as long as they continue to pay the mortgage and are not in default, there cannot be a foreclosure action. The other thing that allows us to do is to take advantage of Florida's statutory, sometimes called wild card exemption of an additional $4,000 of personal property exemption. So a husband and wife go from a total of $2,000 of personal property exemption up to $10,000 of personal property exemption, which can be a significant money saving if you've got a personal property that's worth more than a couple $1,000s. Now, something that's gone on recently is the trustees are trying to say, well, if you don't take the homestead exemption, we're going to sell the house. In other words, they want you to give up your $4,000 each, total of $8,000 of wild card exemption, so then you will have to buy back what now becomes non-exempt assets. They want you to give that up so that they can then recover that money from you. And they say, well, if you're not protecting the house by homestead exemption, we're going to go ahead and sell it. Well, that immediately begs the question, who's going to buy a house that's underwater? And the answer is, there's been a little cottage industry that's developed over the last few years. I like to think of it as about as close as you can get to legalized theft. And what these people do is they've raised some money, they go to the bankruptcy trustees, and even though the house is underwater, they say, well, we'll buy the title from you for $3,500. And then you say, well, what are they going to do with the property? Well, it's very simple. They're not going to make the mortgage payment, so if it's not already in foreclosure, it'll ultimately go into foreclosure. They'll hire a lawyer to fight and delay the foreclosure, and all the while, they'll rent the property out and make money. So if they pay $500 or $1,000 a month for a lawyer to stall the foreclosure, and they're making $2,000 or $3,000 a month in rent, it's a nice little profit. Ultimately, the foreclosure goes through, and they're out. And that's what they're doing. And the trustee is using it basically as a money grab. It's basically intimidate you into taking the homestead exemption, and they get then the now new non-exempt assets that you have to buy back from them, or they get $3,500 from these people who will come in and buy out the underwater property. Now, you can object to this on several grounds, and you absolutely should. Do not allow yourselves to be intimidated into taking a homestead exemption on a property that's underwater. You can object to it on several grounds. One is there's no real benefit to the bankruptcy estate. The only person that's benefiting by this is the trustee, and that's their only motivation. Second of all, it's a breach of the trustee's fiduciary duty to the mortgage lender. They have just as much a duty to the secured creditors, the mortgage lenders, as they do to unsecured creditors. So what the law says is you can't go out and essentially screw the secured creditors by knowingly allowing a property to go into default and the secured creditor loses money in order to get a couple of bucks for the unsecured creditors and several bucks for yourself as the middleman. Even the trustee's official bankruptcy manual says that they should never take underwater property and try to administer it within the bankruptcy estate, that it should be abandoned. And this issue of objecting to these things has come up in a couple of cases, and I want to read you exactly what a judge recently said when this issue was presented. And he said, "I'm not going to be part of approving sales to somebody that's just going to jerk around the mortgage company, rent the property, and then walk away from it after several months. That's just, to me, doesn't serve the public. That's so contrary to the public interest. Simply to bring in a few $1,000s into the estate. We're not going to approve these deals." So when the trustee starts down this road, let them know right away that you're going to object to any attempt to sell the interest in the property, and you're going to raise all of these objections, and in the end, the cost of fighting those objections will quickly exceed what the trustee would have gotten. We've had several of these now where we've told the trustee, we're not going to change our exemptions, and you're not going to sell the property. And we'll object. We had one case where they did file it, both the debtor and the bank, the holding the mortgage, both filed objections. We had another where the trustee was adamant that they were going to do this. Sure enough, the time came and went, and they didn't do anything. So don't allow yourselves to be intimidated by the trustee. And make sure you understand what their real motivation is when they do things like what we've just talked about. Thank you. Again, I'm Eric Lanigan with Lanigan and Lanigan in Winter Park.